भारतीय नागरिक सुरक्षा संहिता 2023। भारतीय नागरिक सुरक्षा संहिता 2023। Section 220 trial for more than one offence. What is Section 220 about? Section 220 is an important exception to the rule of separate trials. It allows multiple offences committed in the same transaction to be tried together in one trial. Main provisions of Section 220. एक same transaction. If a person commits several offences in the course of the same transaction, he may be charged with all such offences and tried at one single trial. To keycap offence made up of several acts. If one offence consists of several acts and each act by itself is an offence, the accused may be charged and tried for all those offences together. 3. One act, multiple offences. If a single act or series of acts constitutes offences under different laws, the accused may be tried together for all such offences. 4. Alternative charges. If it is doubtful which offence is made out, the accused may be charged with all or any of such offences and tried together. Simple meaning: when offences are closely connected, part of one continuous incident, then holding separate trials would be unnecessary and inefficient. The law allows one combined trial. Examples: a person commits house trespass, theft, and assault during one incident, all can be tried together. Forgery of documents, and then using those forged documents in the same transaction, one trial is permitted. A single act amounts to cheating and criminal breach of trust. Both offences may be tried together. Purpose of Section 220: prevents multiplicity of trials, ensures complete and coherent adjudication, saves time and avoids conflicting judgments. भारतीय नागरिक सुरक्षा संहिता 2023. Section 221, where it is doubtful which offence has been committed. What is Section 221 about? Section 221 deals with situations where the facts are clear, but it is uncertain which specific offence those facts constitute. It allows the court to frame alternative charges so that justice is not defeated by technical doubt. Main provisions of Section 221. एक alternative charges. If a single act or series of acts may constitute one offence or another offence or several offences, and it is doubtful which offence applies, the accused may be charged with all or any of such offences or charged in the alternative. To keycap conviction even if specific charge not framed. If the accused is charged with one offence, but evidence proves that he committed a different offence for which he could have been charged under this section, then he may be convicted of that offence, even though no specific charge for it was framed. Simple meaning: sometimes the facts are known, but the exact legal classification is uncertain at the beginning. Section 221 ensures the accused does not escape liability due to legal doubt. while still protecting fairness. Examples: a person receives property knowing it may be stolen. It is unclear whether the offense is theft or receiving stolen property. Under Section 221, the court may frame alternative charges. If charged with theft, but evidence shows receiving stolen property, the court can still convict for that offense. Purpose of Section 221: prevents acquittal due to technical misclassification, gives courts flexibility in framing charges, ensures substantive justice over form. Bharatiya Nagarik Suraksha Sanhita 2023. Section 222, when offense proved, includes a minor offense. What is Section 222 about? Section 222 allows the court to convict an accused for a minor offense even if he was charged with a major offense, provided the facts prove only the minor offense. Main provisions of Section 222: एक major charge minor conviction. If a person is charged with an offense consisting of several particulars, elements, and the evidence proves only some of those particulars, the accused may be convicted of the minor offense, though included offense. The minor offense must be included within the major offense. Example: minor offense is a subset of the major offense. Teen attempt. If a person is charged with an offense and the evidence proves only an attempt to commit that offense, he may be convicted of the attempt even if not separately charged. Simple meaning: if the prosecution overcharges an accused or fails to prove all elements of a serious offense, the court does not have to acquit outright. It can convict for the less serious offense that is actually proved. Examples: a person is charged with grievous hurt, but evidence proves only simple hurt. Conviction for simple hurt is allowed. A person is charged with theft, but evidence proves only attempt to commit theft. Conviction for attempt is permitted. Purpose of Section 222: prevents failure of justice due to overcharging, ensures punishment matches the offense actually proved, balances fairness to the accused with effective justice. Bharatiya Nagarik Suraksha Sanhita 2023. Section 223. What persons may be charged jointly? What is Section 223 about? Section 223 explains when multiple persons can be tried together in one trial. It is an exception to the general rule that each accused should be tried separately. Situations where joint trial is allowed. Persons may be charged and tried together if they fall into any of the following categories. एक same offense, same transaction. Persons accused of the same offense committed in the same transaction. Though different offenses, same transaction. Persons accused of different offenses committed in the same transaction. Teen abetment or attempt. One person committed the offense, another abetted it or attempted it. 4 key cap multiple offenses of same kind, Section 219 cases. Persons accused of offenses of the same kind within 1 year, triable together. 5 key cap different offenses in same transaction, different accused. persons accused of one offense and another offense forming part of the same transaction. 6 offenses involving stolen property. Persons accused of theft, extortion, robbery, or dacoity, and persons accused of receiving, retaining, or assisting in disposal of that stolen property. 7 counterfeiting and related acts. Persons accused of counterfeiting and using or possessing counterfeit items, forming part of the same transaction. Simple meaning: if several people are involved in the same incident or their acts are closely connected, then the law allows one joint trial instead of many separate trials. This avoids repetition of evidence, conflicting judgments, and unnecessary delay. Examples: a group commits robbery together, all can be tried in one case. One person commits theft, another receives the stolen goods, both can be tried together. One person commits the offense, another abets it, joint trial is allowed. Purpose of Section 223: ensures efficient and coherent trials, avoids duplication of proceedings, promotes consistency in judicial decisions. Bharatiya Nagarik Suraksha Sanhita 2023. Section 224: withdrawal of remaining charges on conviction on one of several charges. What is Section 224 about? Section 224 allows the court to stop proceeding with the remaining charges once the accused is convicted on one charge, if the court believes that further trials are unnecessary. Main provision of Section 224: when a person is charged with more offenses than one and is convicted on one or more charges, the court may withdraw the remaining charges instead of continuing separate trials for them. This is subject to the court's discretion and consideration of justice, fairness, and adequacy of punishment. Simple meaning: if an accused faces many charges and is already convicted on a serious charge, then the court may decide there is no need to continue with the remaining charges. This avoids repetitive trials and unnecessary waste of judicial time. Example: a person is charged with theft, house trespass, and criminal intimidation. He is convicted of house trespass, carrying sufficient punishment. The court may withdraw the remaining charges under Section 224. Purpose of Section 224: promotes judicial efficiency, prevents unnecessary multiple convictions, focuses on substantive justice rather than formality. Bharatiya Nagarik Suraksha Sanhita 2023. Section 225: trial to be conducted by public prosecutor. What is Section 225 about? Section 225 states that every trial before a court of session shall be conducted by a public prosecutor. This is a mandatory rule for sessions trials. Main provision of Section 225: in all cases triable by the Court of Session. The public prosecutor must conduct the prosecution. Private individuals or complainants cannot conduct the prosecution on their own in sessions trials, though they may assist the public prosecutor as permitted by law. Simple meaning: serious criminal cases like murder, rape, dacoity, etc. are tried in sessions courts. In such cases, the prosecution is handled only by a trained public prosecutor, not by private lawyers acting independently. This ensures professional handling of serious cases and that prosecution is carried out in the interest of justice, not personal vendetta. Example: a murder case is committed to the Sessions Court. During trial, the case is argued and presented by the public prosecutor. The victim's lawyer may assist the public prosecutor, but cannot replace him. Purpose of Section 225 ensures fair and impartial prosecution, maintains high standards in serious criminal trials, protects accused and victims through professional conduct of cases. Bharatiya Nagarik Suraksha Sanhita 2023. Section 226 Opening Case for Prosecution. What is Section 226 about? Section 226 explains what the public prosecutor must do at the start of a sessions trial. It is the opening stage where the prosecution presents its case outlined to the court. Main provisions of Section 226. 1 key cap opening statement by public prosecutor. When the accused appears before the court of session, the public prosecutor opens the case by describing the charges brought against the accused and stating the evidence by which the prosecution proposes to prove the guilt. To key cap no evidence at this stage. At this stage, no witnesses are examined and no documents are proved. It is only a brief roadmap of the prosecution case. Simple meaning: at the very beginning of a sessions trial, the prosecutor tells the court what the case is about and how the prosecution plans to prove it. This helps the judge understand the case structure and the accused know what to expect in the trial. Example: in a murder trial, the public prosecutor explains the alleged motive, the incident, key witnesses, eyewitnesses, doctor, police, and important evidence, weapon, medical report. After this stage, the court moves to the next step, consideration of charge. Purpose of Section 226 sets the foundation of the trial. ensures transparency of prosecution case, assists the court in deciding whether charges should be framed. Bharatiya Nagarik Suraksha Sanhita 2023 Section 227 Discharge. What is Section 227 about? Section 227 empowers the Court of Session to discharge the accused at an early stage. If, after examining the record, the judge finds no sufficient ground to proceed. Main provisions of Section 227. एक consideration of record. After hearing, the public prosecutor and the accused, the sessions judge examines. Police report, documents sent with it, and records of the case. Though ground for discharge. If the judge considers that there is no sufficient ground for proceeding against the accused, he shall discharge the accused. 3 reasoned order. The judge must record reasons for ordering discharge. Simple meaning: before framing charges, the Sessions Court checks whether the case is strong enough to go to trial. If evidence is weak or allegations do not disclose an offense, the accused is released at this stage itself without facing trial. Example: police file a charge sheet for murder. Court finds no eyewitness, no forensic support. Allegations are purely speculative. Under Section 227, the Sessions judge discharges the accused. Purpose of Section 227: protects innocent persons from unnecessary trials, filters out weak or groundless prosecutions, saves judicial time and resources. Bharatiya Nagarik Suraksha Sanhita 2023 Section 228 Framing of charge. What is Section 228 about? Section 228 explains what the Court of Session must do if it finds that there is sufficient ground to proceed against the accused. It is the stage after discharge, Section 227, and before the trial begins. Main provisions of Section 228. एक when charge is framed. If, after consideration, the Sessions judge believes that there is ground for presuming that the accused has committed an offense. To key cap cases triable by Sessions Court. If the offense is exclusively triable by the Court of Session, the judge shall frame a charge in writing. 3 key cap cases not exclusively triable by Sessions Court. If the offense is not exclusively triable by the Sessions Court, the judge may frame the charge and transfer the case to the appropriate magistrate for trial. Char explanation to accused. The charge must be read and explained to the accused, and the accused must be asked whether he pleads guilty or claims trial. Simple meaning: if the court finds that the case appears strong enough to go to trial, then it formally frames the charge and moves the case into the trial stage. This is not a finding of guilt, only a decision that the case deserves a full trial. Example: in a murder case, court finds prima facie evidence. Under Section 228, the charge of murder is framed, explained to the accused. Trial begins thereafter. Purpose of Section 228 separates weak cases from trial-worthy cases, ensures accused understands exact charges, marks the formal beginning of sessions trial. Bharatiya Nagarik Suraksha Sanhita 2023 Section 229 Conviction on plea of guilty. What is Section 229 about? Section 229 explains what happens if the accused pleads guilty after the charge is framed in a sessions trial. It gives the court discretion to convict the accused based on that plea. Main provision of Section 229. If the accused pleads guilty to the charge framed under Section 228, the sessions judge may record the plea and convict the accused on that plea. The word may is important. Conviction is not automatic. The judge can still consider the seriousness of the offense, ensure the plea is voluntary, informed, and genuine, and decide whether to proceed further or not. Simple meaning: if an accused admits guilt openly in court, then the court can end the trial early and convict him without examining witnesses or evidence. But the judge must be careful that the accused understands the charge and the plea is not made under pressure or misunderstanding. Example: an accused is charged with a sessions tribal offense. After the charge is explained, he says, "I plead guilty." Under Section 229, the judge records the plea, convicts the accused, then proceeds to hear him on sentence. Purpose of Section 229: speeds up criminal proceedings, saves judicial time where guilt is admitted, ensures voluntary and informed admission of guilt. Bharatiya Nagarik Suraksha Sanhita 2023 Section 230 Date for prosecution evidence. What is Section 230 about? Section 230 explains the next step in a sessions trial when the accused does not plead guilty. It directs the court to fix a date for the prosecution to present its evidence. Main provision of Section 230: if the accused does not plead guilty or the judge does not convict on the plea of guilty under Section 229, then the judge shall fix a date for the examination of prosecution witnesses and for production of prosecution evidence. This formally begins the evidence stage of the trial. Simple meaning: if the case is going to be fully tried, the court moves forward by scheduling hearings for the prosecution to prove its case. The prosecution now gets the opportunity to call witnesses and produce documents and material evidence. Example: an accused pleads not guilty to a murder charge. Under Section 230, the sessions judge fixes dates. Prosecution starts examining witnesses like eyewitnesses, doctor, post-mortem, Investigating Officer. Purpose of Section 230 marks the start of the evidence phase of the sessions trial, ensures an orderly and time-bound trial process, gives prosecution a fair chance to prove the charge. What Section 231 says? Section 231 of the Bharatiya Nagarik Suraksha Sanhita 2023 deals with the rights of an accused person to receive copies of certain legal materials in specific cases. When it applies. This section applies when a case has been started not on a police report, e.g., a private complaint or other origin, and it appears to the magistrate.